All rise. The District Court of Appeal of the State of Florida in and for the Second District is now in session. The Honorable Patricia J. Kelly, Judge presiding. Those having business before this court, draw near, give attention, and you will be heard. May God save the United States of America, the State of Florida, and this honorable court. You may be seated.
Good morning. Welcome. Quick reminder, everyone has 20 minutes to set their argument. If you're the appellant, you can reserve a little bit of that time for rebuttal. If you don't remember to ask me, I'll probably save you a little bit of time anyway. So we're ready to begin. Our first case this morning is Doss versus Department of Revenue.
Good morning, judges, and thank you for the opportunity to in the audience. And I want to reserve any remaining time I may have for training.
Okay.
And it may please the court, I'm the appellant, Brett Doss. And this honorable court should grant this appeal because the trial court abuses discretion when it didn't involve a well-established law, particularly Rule 1.070K. The Florida Rules of Civil Procedure requiring service process of the initial complaint, especially when the Department of Revenue attorney never met caveats of showing good cause for failing to execute service process, and nor did they receive an order from the court extending time beyond the initial 120 days. And because the trial court abused its discretion, it never required jurisdiction over it. And thus, it never had the power to enter not only the original judgment, it definitely couldn't enter or put out any future subsequent orders related to that case.
Now, the department's going to talk about the concept of waiver. Are you familiar with the concept of waiver from their briefs? I'm assuming.
Yes, I am.
You're prepared
Yes.
to speak to that and why your multiple appearances before raising the issue of service didn't waive your right to raise that as an objection.
Well, this was on many years later, but you to waive service, to waive any given right, it has to be unknown involuntarily, and that was never done in the state. More importantly, I never seen before.
Well, what do you think the purpose of service is, though?
To inform a person that they have a work.
So, right, so, didn't you appear at perhaps 8 or 9? I could count them up by the earlier I got from the record. A large handful of times before you ever raised the issue of the fact that you never received service process, and you actively participated in litigation regarding your paternity without ever objecting to process of service. You showed up, you argued against it, you showed up at multiple hearings.
I'll state that I never should have volunteered. I should have under extreme threat of arrest corporation because the honor of this court is made when they send these messages out. One of the interesting parts of the service is that you don't come to the issue of arrest, you want to arrest the issue and what have you. But I'm going back to the fundamental.
That applies to everybody, including those who receive service process, right? Whether you got service process or not, you have to show up, or else there's penalties, right?
But I would go back and say the service has to be proper. In this case, service is proper.
Now, I'm making the other side's argument for because you're the one standing up here. Service has to be proper, and I'm going to guess, and I'm not going to speak to the other side, but just hypothetically, they might say, "You're right. You didn't they'll just concede you didn't receive proper service." But there's a case law that we have to follow that says you can waive that argument when you show up and you argue the case on your behalf, whether through a lawyer or yourself. You show up, you say, "Okay, I'm here. I'm ready to contest paternity." And time again, hearing after hearing, motion after motion, order after order, you never raise the argument that there was a technical violation of the statute that provides for the procedures for service process. And that's probably what they're going to say. And that's probably what you need to address. In other words, you can argue all day that the service of process was improper, or you didn't even get service of process. And I'm not going to speak for them now, but just hypothetically, what she might say when she gets up here is, "Okay, fine, we didn't serve process, but you were there all along at all these hearings because you got notice somehow, and you showed up and you made argument, and we have to follow laws in cases that bind us that says you can waive your right to argue service process." So what's your response to that?
I would say that was probably after, because it's a considerable amount of time, they probably just complained, and I wasn't going to get into the pleading, aspect of the case because they had to play facts sufficient to give them the order for a jurisdiction anyway. And that wouldn't have happened because and I didn't want to bring up this later on, in my argument. I wasn't going to name the mother in here because it's not really important. The mother, nor the now 34-year-old individual, never lived in Florida. And the state that I believe he was born in North Carolina, because he was captain when I was in the Army back in 1989, along with the mother. So if North Carolina was the state of his birth, and at the time I was in Texas, it'd be kind of interesting to see how, or what their argument would be, how they would have played it back to the get it Florida, they can bring any action on behalf of a party outside of
Where there's laws that are adopted by all the states that provide for all of this cooperation among states. So in 1999, there was a hearing on a motion to compel genetic testing, and you were present.
Right.
Yeah, that's in the record. So did you raise the issue of lack of service of process?
I don't recall what the issue was. I wasn't in
The record reveals that you did.
I
And then you argued against being tested, right?
against because they already done. I didn't understand in terms of.
Then there was a hearing at which there's a 99.96% probability that you were the biological father, and you argued against that. You had your opportunity to argue against that, but you lost. And did you argue the fact at that time when you showed up and argued against that genetic testing that there had been a technical violation of the service process?
I can't recall.
Well, the record says you did.
No,
So my question is, how are you going to get around the argument that I'm predicting, just hypothetically, the department's going to make that says if you show up, and this doesn't matter if it's a breach of contract case, if it's what kind of case it is, if you appear with your lawyer or by yourself to represent yourself, and you don't tell the court then that the other side that brought this action violated the service process requirements, you're not going to get to argue that.
Well, I understand that we did. Can't recall specificity, but exactly our argument, positive argument that this issue is addressed nomination in court at orderless statute, and her manager, contact manager, went through this process. And the Army told me was one for everybody. Had a soldier impregnated another soldier. The Army was held together. Now, I was in this question, but since we're here on the present, if in fact it was done to her, the child was born in North Carolina, and I was in Texas, again, even with the international or the universal law that allows the states to cooperate, they still have to cooperate with the law. And the rule 1.070, and I know it's been changed since this time, it still had to conform with the federal rules for them. It required that they had to strictly comply with certain process, and we know the jurisdiction cannot be stipulated. I think that we just forget about the law until
the department's. I read all the briefs, obviously, and so the department's going to get up here and say that it's not jurisdictional. In other words, the court has subject matter jurisdiction, meaning the court, legislatures, sets up courts, and the Constitution sets up courts, and they have subject matter jurisdiction. The subject matter is paternity, and so they had jurisdiction. And then jurisdiction over a person can be achieved in a number of ways. Service of process, or you showing up and arguing, which you got an opportunity to do. And I could go through the list, right? So we went in 1999, and then in 2000, there was a hearing on the findings of the genetic testing results. You appeared and had the opportunity to argue against that. You did not argue that there was lack of service of process. Let's see, the hearing granting partial summary judgment, you were present, you did not raise notice of service of process. The first time you raised this issue was, I think, in 2022, the specific issue of the failure to serve process.
2012, and see that motion challenge subject matter jurisdiction.
The subject matter jurisdiction is different. That's what I was talking about. Courts have subject matter. The subject is paternity. There's no question about that. The question of that you're raising in this appeal is that the department didn't follow the requirement to serve process in 120 days. And that, the first time you raised that was last year.
I think we've been ready when I filed a motion with the record of October 2012, I found subject matter jurisdiction. And first, when we're going to look at the subject matter jurisdiction, the department would have to feed facts and give the department jurisdiction because the mother never filed an independent action, to my knowledge. Hence, the department never had a general standing because we know the rule 1.040 of the Order of Criminal Procedure state quite clearly that the attorney that is inherent on any appears on behalf of the agent. The mother never brought an action against him. We're going to talk about the jurisdictional action. The department never brought a standing. It'd be different here.
Well, they have it's their job. That's by statute. We'll go back to your point about your 2012 filing, but your notices of special appearance. And that's an interesting aspect. So let's, for the sake of discussion, we'll presume that it's a similar argument, if not the same argument about service, but it's about personal jurisdiction. So then there's a special appearance. The concept of special appearance, one way of stating it, let's just talk in the vernacular, if you show up, if you or your lawyer shows up at the first time someone brings an action, the Department of Revenue, or you're sued for somebody, slips and falls and gets hurt on your business, if you get sued and the first time you show up, you say, look, I'm showing up here, but I'm just showing up just to say that you don't have jurisdiction over me because the plaintiff didn't serve the process properly. That should have happened in 1999. 1999, if you or your lawyer showed up and said, look, I'm here because I've been made aware that there's this paternity action against me, and I'm just showing up to tell you, court, that the plaintiff didn't properly serve me. That would have preserved your argument regarding service of process that you made, whether it's 2012 or 2022, a decade or two later. And that's what they're going to argue. So we all we can do as this court is decide whether the court from which you appealed got the law right. And I'm telling you, after looking at your briefs and the briefs of the department, what I think the law says. And do you have any cases that would create an exception that I'm not aware of?
Well, if we talk about just strict compliance with the rule,
but they're going to say, yeah, we didn't strictly comply with the service of process.
Because they could not, based solely on the fact that there's no minimum contact that would have given the court any ability to do on behalf.
And that's a little different than that. You're talking about personal jurisdiction. I mean, you're right. You know a lot about the law, obviously. But you're talking about. Okay, but that's not what we're here about. That's not what we're here about. And I understand you might have made that argument past personal jurisdiction, the state court over you. But what we're talking about is being served with the action,
And I would once again rely on the fact that strict compliance and all the terminals line of if it states with this must be done. They didn't do it. And now they're going to come back later on and say, well, we didn't follow along. The courts are now in the NAPSC courts, but let's not forget that this is an administrative hearing. And in the administrative hearing, there was never any testimony, never any evidence provided because no one was sworn in. And the only one who was spoken at these hearings would have been the attorney for the department. And we all know that it's stated by attorneys of the council. So there's no testimony for the court to rely on for anything. And because this the mother, nor the not very individual, Peter personally, never been she probably named by the city. So we did at least a clear factual basis where did we deal with this issue back in 1989 when I was never out of death in the Army and you were at Fort Bragg in the Army, both soldiers, and really even if any contact whatsoever would not have happened in the United States, but I had seen her without an attorney. Now, again, It's almost.
Mr. Dawson, I'm sorry to interrupt you, but I did want to let you know you're at your appointment.
Okay, well,
You can use it however you wish.
I just want to make sure that I'm clear that the law is continuing to, one must comply with, strictly comply with the rules of service process. Argument that they didn't. They didn't do it back in 1995 when the case was filed. They had 120 days. They didn't do anything for 1,000 days. That's in the record as well. If you, and I can go over it and I'm probably losing my mental rebuttal, but I kind of have an idea what they're going to say because kind of getting into it. They filed the action May 15, 1995. And on February 9, 1998, they amended the complaint. And I think at one time they amended the complaint without permission from the court. Then after February 9th, 1998, I mean, they didn't do anything for still another 120 days. They never got permission from the court for an extension of time beyond the original 120 days. When they show good cause. And there's basically case law about the good cause aspect for them to show why they didn't serve process. They were never under scrutiny. The Department of Revenue never under scrutiny. They come in, they look at the funding process. The courts rubber stamp ruling. They don't have testimony, at least in this case, they have no testimony to support any of their facts. They never submitted a witness. So we're talking about fundamental process of all that. And if there's another appeal or some other function, I'll do that. And I'll remember the rest of my time with what he may bring up.
All right, you've got 4 minutes.
Thank you.
Not really sure which order Mr. Dawson is arguing. That's what we're here on. The order in my motion to keep the service list, not extend the service list. And in that order, we're not specifically found that he didn't have jurisdiction to vacate the order. So we're kind of premature in that there was no decision on whether or not the order should be vacated. And I think that certainly order is not going to be vacated for all the reasons that, you heard and I raised them and I think also the argument was waived, it should be made on the vote, should be made at the first hearing. You can't come in years later in a special appearance once you've already made your general. Whether or not the OR has already been this state law between them. Further, it doesn't matter where the child is born, Mr. Dawson was in Florida at the time the action was sent to Florida by the other state of the United. So it started under RISA and then it was amended by the state. So the OR definitely has standing. 1.070 is more of a health inspection to keep the case moving. The OR was, if Mr. Dawson is now saying that it should exist, that's not correct. We would be given the opportunity to explain why they was play. Again, Mr. Dawson waived that. The courts covered this pretty well, and I have the same arguments in my brief, so.
Well, there was a 2012 filing, the special appearances. Mr. Dawson said he raised the same argument he raised in the order from which this bill was taken. Is that correct? That there was a service process argument back in 2012, or was that just a personal jurisdiction argument? Okay, it was amended notice of special appearance to challenge jurisdiction of the person in subject matter. But I can take that up with them. That's in the record.
But
But
he
that's-
still had appeared.
He did.
Right.
And
So I don't know.
in the paternity proceeding.
I'm not aware of having any special hearing again. I can go on with my brief, but
Thank you.
Is it, good help for I cited in my brief, Great American Insurance because in back 1995, this court, confirmed that a judgment entered without valid service is void for lack of personal jurisdiction and may be collaterally attacked at any time. So I don't know how any time is any time or we're not, but also
Say that again, that it's void for what? Lack of.
personal jurisdiction.
Now, again, there's a distinction between personal jurisdiction, which is what I believe when I looked at the record here, argued back in 2012, and counsel for the Department of Revenue talked about that issue about you being in Florida, and but that has come and gone. That was a determination made based on your special appearance in 2012 that you could have appealed. Maybe you did appeal. I can't remember from the record, but that's over. This is about service. That's the argument you raised, is service, whether you were properly served with this action. And I want to talk about what the Council Bureau just said, that there was an important point that she made. And again, I'm going off the bridge. We come here fully prepared. That's why I feel like, I wanted to make sure I explain the way I see the case, and you could argue against it if you want. But if they had been put on notice, if you had done the special appearance in 1999, the first time you got the paternity action against you, then the department, who the legislature wants to stop, whoever made the determination, brought the action about paternity, would have the opportunity to properly serve you. It's not as though you don't get out of the whole action just by saying you weren't properly served. If you had raised that in 1999, they would have an opportunity to properly serve you, to correct that. But you never raised it. So now, a decade later or 2 decades later, that's why we have to follow binding case law decisions that say individuals who are sued can waive service by showing up and arguing the case, which is what you did.
And I believe that way would also have I can't call the case, but I believe that way would known in voluntarily. And
Well, you voluntarily showed up and you argued against paternity. But again, that part of it, that coercion, you can take that up with the legislature. Take that up with the legislature. That coercion exists whether you're properly served.
I understand if you're asking, and let's go back again. They have the department has standing, they would have a sufficient justification in Congress. They never raised one. In fact, I know that whenever the court issues an order outside of the court meeting, they can say that I owe anybody any obligation whatsoever. Now I'm talking about morality. Basically morality. We're talking about the black letter of the law. What if they did not believe anything and they could never have the jurisdiction part of the way and would have to deny how to waive my right to come to the process because there are viable alternatives to include what she can't do it because she doesn't have the financial capacity, mental capacity, or emotional capacity. You can't tell me that they cannot be the father an opportunity to raise their argument and not involve the right for the school to be right to come to the process of protection of the law. But that looking with this, I think it's involved into that. It's in praise out of pressure. But right versus right, it's going to all work. You can't say, I know that you didn't do something right here, and I'm going to take responsibility to protect the rights of everybody. And you failed to adequately follow the law in the service of the process. You know you didn't have any witnesses, so anything that said based upon the recommendation, based upon testimony, that would be a terrible representation.
Doss, thank you. Please wrap up, please.
Oh, thank you for your time. Thank you for your audience.
Thank you. Our next case this morning is Apple versus PCC.